Now, once the labor certification of the perm has been approved, once the I-140 has been filed, then we look at stage 3. This is the final application. This is the actual application for the green card itself. Now, we were talking about preference categories. Well, this is where the stage 3 comes into play. The application for adjustment of status with the 485 may not be filed until the priority date is reached for that person in the preference category, the applicable preference category. The filing of the perm application establishes the priority date. So obviously you can file your perm application. You can file your I-140, but you may not file the 485, the adjustment, until your priority date is reached. And again, the visa bulletin published by the Department of State is a good place to track every month and see how those dates are moving. Okay. Now, I had said earlier that the perm application, even if it's an issue to you, it does not give you legal status to stay here. It does not give you permission to work. It has the word labor in there, but it is not employment authorization. When you file your adjustment application, however, filing of the adjustment application of the 485 does give you legal status. So if your H-1 is expiring or your status is expiring, maybe you're able to go directly from F-1 student status to the green card. You don't actually have to get the green card approved before your F-1 expires. You just have to get that 485 filed. Filing the 485 gives you lawful status to stay here. It also entitles you to apply concurrently with the 485 an application for your work authorization. So it is very, very beneficial. It allows you to apply for your work authorization, commonly called an EAD or employment authorization document. Not only does it allow the primary applicant to file and to get status and to apply for work authorization, but when the primary beneficiary files his or her adjustment application, the spouse and all of the children who are under age 21 can file their own separate applications for adjustment of status in 485. That too gives them status to remain in the United States, and it also entitles them to apply for their own work authorization or their own EAD. The nice thing about an EAD while the adjustment is pending is that it is not restricted to any particular employer. When we were talking about the H-1s, then a person who is on an H-1B visa may only work for the sponsoring company who submitted the petition for the H-1 and was approved. Whereas the EAD, based on the filing of the adjustment application, is not restricted. So I don't care if you're a college professor and you've been sponsored for your research work. Once you file your 485, once your work authorization or EAD is issued, if you want to take a part-time job at McDonald's, that's perfectly fine. There's no problem. Okay. Now, one of the important points to keep in mind is that you're getting the green card, or the beneficiary is getting the green card in order to work for the sponsoring company in the specific job that was specified in the perm application. That means that that job must remain available to the beneficiary at the time that the Immigration Service is ready to issue the approval for the green card. What happens if a person is in one of those countries or from one of the countries where there is a 5 or 6 or 7 year backlog, and they have gotten all of their applications filed and approved, and they're simply waiting for the priority date? The priority date has finally come, and they filed the adjustment application, and they're just about to receive their application or their approval for the green card, but the company notifies the entire staff that they're closing this Friday and they're shutting down. The job no longer exists. There's no longer any need for your services, and therefore the green card cannot be approved. Your case will come to a halt. Now, there is an exception to that, because that is an extremely harsh rule, given the circumstances and the fact with this economy, there were companies that were having financial problems that were closing. So there was passed by Congress a procedure referred to as the AC-21 letters. And that basically allows a person who has already filed their adjustment for a period of time, 180 days, to substitute a new position as long as the new position is similar to what they were originally approved for with the first company. The AC-21 substitutions, all the requirements have to be met, but it can be extremely beneficial, especially in today's economy. Okay. Now, in order to even file the 485, it is important that the beneficiary keep in mind that he must have maintained status the entire time while he has been on a temporary visa. So he must be complying with all of the rules for an H-1. The family must be complying with all of the rules to be an H-4. They may not work. And as long as everything has been fine, their perm is approved, the I-140 is at least filed, then they can file the adjustment. And assuming that the job is still there at the time that their green card is issued, then they will get their green card. They will become U.S. permanent residents. We have covered a lot of material in this segment. So what I offer to you is, if you have any questions or you want to get some clarification or you want to discuss your case, please do feel free to give us a call. We'll be happy to talk to you and give a little bit more information and evaluate your documents and talk to you and try to help you out in any way we can. Thank you very much. I appreciate your time.